So emotions are running really high in the Karen Reed case. We have a hearing coming up on Monday where hopefully it's going to be open to the public. We'll be able to see exactly how the hearing goes. And this is a very important hearing. It's on a motion to dismiss count 1 and count 3. Count 1 being second-degree murder, count 3 being fleeing the scene, and just be that the Commonwealth should just be able to retry Karen Reed if they choose to on just count 2. Now, before I jump into the analysis on the jury note, which this is a lot of the analysis today is going to be on the jury note because that's what a lot of people want to talk about. They want to talk about charges. What does the charges mean? Do the charges mean the charges in count 2? Do the charges mean all of the charges? And people are arguing about this till they're blue in the face. So here on Brother Counsels, what we do here is we try to be the voice of reason. We try to explain things, how the lawyers and judges look at these issues and how the law looks at this issue. It's not about feelings. It's not about how you're feeling inside, whether you feel it's fair or it's unfair. That's not how it works. Okay. You have to go back to the law and see what the case law or the statutes or the rules of evidence or the rules of criminal procedure, what they have to say about a scenario like this. That's how you analyze this, not about how it just feels not right. It just doesn't feel right. Okay. We can't help your feelings. If you want to win something in court, you have to bring a basis. You have to show the judge, Your Honor, this is the basis in the law that I have to get what I'm asking for. That's what you have to do. And we explain this a lot of times on this channel. You have to cite to the authority, which gives the judge the ability to give you what you want. You can't just come to the judge and say, it's not fair. The jury is all coming out a month later saying that they really acquitted her on count 1 and count 3, and therefore it's not fair. That's not going to do it. Okay, it's just not going to do it. And maybe you can just be on your couch and be upset about this, but when you're in the court of law, you got to follow the rules. And the rules are that you got to find authority for positions that you're taking. So that's what we do on this channel. We explore the law and explain the law and break it down, how we can all understand what the law provides in these type of situations. Now, before I jump into it, I just want to remind everybody, again, this has nothing to do with whether Karen Reed is guilty or not guilty. We've already broken that down based on all the evidence that came out during this trial. I felt that the Commonwealth did not meet their burden. They did not prove beyond a reasonable doubt that Karen Reed was guilty of any of the counts, in my opinion. Okay. But that has nothing to do with this specific motion. All right. So let's try to separate the two and let's just look at this as a motion to dismiss based on double jeopardy and based on the law in Massachusetts. Okay. So that's what we're going to be doing. So we're going to be jumping into the note that the jury sent back. And this was the final note. But first, I think it's important because people are saying, well, it's open to interpretation. It's open to interpretation. What do the charges mean? Do the charges mean just the charges in count 2, or does it mean all the charges? And now that the jurors are coming out with all their affidavits, that should make a difference. Well, should it make a difference or not? So people are just talking about what they feel. Some lawyers are also doing this, by the way. Yeah, sure. I mean, if the jury's coming out now and there's an ambiguity in the note, so therefore, we should have an evidentiary hearing. But let's not forget, okay, what we do on this channel is we go back to the basics. And every time things get a little convoluted and complicated, what you have to do is go back to the basics. And the back to the basics means stop. Has there ever been a case like this in Massachusetts where there's opinions, where there's case law, or is there a rule that talks about what to do in these type of situations? And then you start to compare and contrast the different case law that have to do with these type of situations, and then see whether there's any basis for what you're asking for. So number one, we have an ambiguity. Let's just assume, okay, for the sake of argument, that there is an ambiguity in the jury note that they sent back. And we're not sure what they mean. All right, now the judge did what she did. She ordered a mistrial based on the note. Okay, so we have to look at that through the law. So you have an ambiguity in a note, and you have a judge declaring a mistrial because of that, because maybe she misunderstood the note. Maybe the note really meant that they're only hung on the charges in count 2. Okay, let's just play that out, because there's a lot of people out there that are very strong that this is a real interpretation and it's a fair interpretation of that jury note. Now, Personally, I think it's a stretch. I think that when you say you're hung on the charges, you mean all the charges. If you meant the charges in count 2, you would say we are hung on the charges on count 2. And then some people will say, well, they didn't know that they're able to say that they're only hung on the charges of count 2 and not the other charges. And therefore, you can still say we are hung on some of the charges. So you're not explaining which charges you're hung on, but you're expressly saying that you're only hung on some of the charges and not all of the charges. Now, you didn't write all of the charges, but still the fact that you didn't limit it in any sort of way would lend us to believe, and especially, let's remember, right, these notes are so articulate. Whoever the foreman was, they really spent time thinking about it. It's not like they just quickly wrote off a note to the judge without thinking about it. This is a jury, and certainly a foreman or forewoman who was thinking carefully about how they're wording the note. And if they meant that they're only hung on charges that are associated with count 2 and not count 1 and count 3, then there should have been some sort of language that would indicate that, right? So that's one argument to be made. Now, okay, I'm not going to, we're going to play it all out. Okay, we're just going to play it all out. I personally think that certainly it's much more leaning in the way of interpreting that note to mean that they were hung on all the charges. Now, they didn't say all. I understand. I agree. That's not what they said. They said the charges. Still, my simple understanding of that is that the classic interpretation, without reading so much more into it, is that they're hung on all the charges. Okay, but for the sakes of this video, we are going to assume that there's two viable interpretations to the note. Okay, but let's just go through the first note, the second note, and the third note. And I haven't been hearing too much about the first note, because let's look about the language of the first note. All right, so the first note said the following: I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. What does that mean, that we have been unable to reach a unanimous verdict? Does that mean a unanimous verdict on count 1, count 2, count 3, all the counts, count 1 and 2, count 2 and 3? Is that ambiguous? Are we unsure about that note also? Because I think that now that I'm pointing this out, maybe some people say, yeah, well, maybe they just meant that they are unable to reach a unanimous verdict just with count 2. Now, I haven't heard that argument yet. Maybe this argument's out there. Maybe people start thinking about it now. But certainly, you can make that argument. The same way you're making the argument about the charges, you can make the argument that a unanimous verdict just means a unanimous verdict for count 2. All right. But I haven't heard that argument, but maybe people start making it. So now that was count number 1. That was jury note number 1. Now we have a second note. Listen to this note, and maybe you can explain to me what this note means. Judge Cannoni, despite our commitment to the duty entrusted in us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implication it holds. Now, is that just a bunch of nice articulate sentences that actually are not telling us whether you're hung or not? You're saying that you have deeply divided fundamental differences in your opinions. About which count? Count 1, count 2, count 3, all the counts? Is anybody raising their hands about this note as well? That, oh, this note you also see that we have no idea which count they're talking about. Well, I guess you can certainly make the argument that we don't even know what they're divided about, which count they're divided about. But it seems that nobody had any issue with understanding the first two notes. It only gets to the third note. All right, well, let's move on. So now we have the third note. And because I didn't say it verbatim in my last video, let's say it verbatim this time. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges beyond reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. And this is where everyone's starting to throw their hands up, arguing that here the charges does not necessarily mean all the charges. It means just the charges in count 2. And I think that if you would like to make that argument, that's fine. But then you're going to also have to apply that same logic and say that that's also what the first 2 notes also meant. All right. So let's just understand the argument completely. Now, okay, you don't have to say that. Maybe you could say, well, maybe by note 1 and note 2, it was all the charges, and now they changed, and now they've reached a verdict on the count 1 and count 3 after the Tweed Rodriguez charge instruction. Okay, whatever. I'm just pointing out that certainly you can make some of these same arguments that there's ambiguity in the first note and the second note as well. Now, let's talk about whether there's any basis in the law to bring back a jury to talk about what they voted. Okay, so this is important, right? Because what you have to do as a lawyer, certainly when you're filing motions and briefs in front of the judge, is to give the judge the authority. Give the judge the authority that allows the judge to do what you're asking. So number one, you're asking that completely count 1 and count 3 should be dismissed because we have jurors that are coming out afterwards saying that all 12 of us agreed on count 1 and count 3 that Karen Reed was not guilty. So is there any case law out there, or any rule or any statute that says that when you have jurors afterwards that come and meet with the defense attorney, and the defense attorney files an affidavit on behalf of them, that count 1 and count 3, or any counts that the jurors are talking to the attorneys about, that they get dismissed, just flat out, without anything? No, there's no case law like that. So let's understand each request, and then we'll be able to look at that through the law. The first request, we have all these jurors coming out, therefore count 1 and count 3 should be dismissed, just like that, without having anything more to do in court. No, there's no case law like that at all. The only suggestion is where you have to bring the jurors back. Okay, now in what situations are we allowed to bring the jurors back? Okay, it's not just about this just doesn't feel right. It doesn't feel right, so let's just bring them back and let's make things right. That's not the way it works. Okay, it's just not the way it works in the court of law. You've got to show the basis for that. What case tells me that you can do that? What opinion? What statute? What rule? So you have to look to the rules. What rule says that you can bring the jury back, and ask some questions? Well, the only case that the defense quotes in its brief is the case of Commonwealth versus McCallop. Commonwealth versus McCallop was when there was racial and ethnic bias that was injected into the conversations in the jury deliberations room. Okay, so we find a case where the judge was allowed to call back the jurors and ask them about this racial bias that was injected into the conversations in the jury deliberation room, and then the judge was able to vacate the verdict. Okay, so now you have to ask, okay, fine. So now we found an area in the law, a case in the law, this opinion, which says that you're allowed to bring the jury back. But the problem is this situation the same as that case? Just because you find in one case that the judge is allowed to bring back something which everybody would agree you have to come back, and there's an explanation in this opinion, Commonwealth versus McCallop, which explains why when it comes to racial and ethnic bias, of course, you have to bring the jury back. We can't have verdicts based on racial and ethnic biases. So, of course, the judge lays out why it's so important when it comes to that type of bias, that type of prejudice, that we're allowed to bring the jury back. Okay, what about this case? Here in the Karen Reed case, there seems to have been some confusion. There's some confusion in what the jury was allowed to do. They wrote out a note. Maybe charges means this, maybe charges mean the other thing, and the judge declared a mistrial. So where do you see anything in the Commonwealth versus McCallop case that says that in this situation, you're allowed to call the jury back? You don't. So it's not the greatest case to quote. If that's the only case you've got, it's not the greatest case to quote. But don't worry, because I did some more research just for you. I did this research because if you look in the defendant's brief and if you look in the Commonwealth's brief, you're not going to find the next two cases. Well, at least for sure the next case. The next case is a case called Lapham versus Eastern Mass. Eastern, it's Lapham versus Eastern, and it's spelled Lapham. And what happened in this case, actually, was that there was a mistake on the verdict form. They filled out the verdict form, and they made some mistakes on the verdict form. It was unclear what they meant. Okay, so it was unclear what they meant in the verdict form, and they were dismissed. And the judge, when they were first called out and read their verdict, they read the verdict in one way. The judge asked, the judge read it, and the jury agreed that was their verdict. But then, when they looked through the entire verdict form, they realized that there's more things that were filled out that would contradict some of the verdict that they expressly said in court that was their verdict. So that was the problem there. They filled out two different verdict forms and they didn't seem to match. So what happened in that case is the judge called them back. And the judge called them back and asked them to, which verdict do you really mean? Sent them back into the deliberation room, and they came back with a final verdict. Now listen to what the opinion says in this case. Because if you were the defense, you would absolutely want to quote this case. They didn't quote this case, and they didn't ask brother counsel. Otherwise, I would have told them that they should quote this case. This is what the case says. When a jury reached a verdict, but it was improperly reported, we have allowed a correction to be made. Well, full stop. When a jury reached a verdict, but it was improperly reported, that sounds exactly or very, very similar to our case, because here the jury did reach a verdict. Let's just assume that all this says coming out now is true. Let's just, for the sake of the argument, the jury came out, they agreed on count 1 and count 3 that's a verdict. So the jury reached a verdict, but it was improperly reported because they wrote charges on the note. They really only meant, let's just play this out, they really only meant the charges in count 2, but they really found a verdict for counts 1 and count 3. So we have allowed, the opinion says we have allowed a correction to be made. So here we have straight out case law that says you're allowed the jury to come and correct what was improperly reported. This sounds exactly like this case. How can you not quote this case? Defense. A discrepancy between the verdict actually agreed upon by the jury and that reported by them may, upon proper proof, be corrected after the separation of the jury. That's also another straight out quote from this case. So after the jury already separated, they're going home. It could be corrected. So this is exactly our case. How can you not quote this case? This is like the perfect case to quote. Well, the answer is because it's not so simple. Why not? Because what happened in that case actually was very different than what happened in this case. It's still a good case to quote, and I still think that if you're the defense, you should quote this case, much more so than the Commonwealth versus McCallum case. This is a case that's much more similar to your case, because this is the problem. This is what the opinion there continues. This is, again, Lapham versus Eastern Mass. However, the separation of this jury after rendering a sealed verdict, which is inconsistent or defective, has been held not to prevent the submission of the case to the jury for further consideration so this is continuing with this idea that just because the jury separated doesn't mean that you cannot call them back to make things consistent. But it's only if the judge determines that nothing prejudicial to the cause of justice occurred during the separation. So, if the judge can determine that nothing prejudicial to the cause of justice occurred during the separation, what happened during the time that the jury was let go, sent home, and the time by which you called them back. What happened? What elapsed? How much time elapsed? What did these jurors do? So the opinion continues. In the instant case, the mistake obviously arose from a misunderstanding on the part of the jury as to the use of the verdict slips. There was a lapse of but 5 minutes between the reporting of the original verdict and the reassemble of the jury in the jury box. So there was only a lapse of 5 minutes. And the opinion is stressing this for a reason. That there was only a lapse of 5 minutes. They were still within the courthouse when the judge was able to call them back because there was an obvious mistake on the verdict slips. It is unlikely, this is what the opinion continues, it is unlikely that anything occurred in that short intervening period which would imperil in the slightest degree the purity and absolute impartiality of the jury. So there you see straight out that the reason why in this specific case, Lapham versus Eastern Mass, they had no problem calling back the jury, which almost the facts in that case are very similar to what happened in Karen Reed, allegedly. Again, if we're going to buy everything that the defense is selling, let's just play that out. And that the charges just meant the charges in count 2. And there was a real ambiguity in that note. And really all the jurors voted 12-0 on count 1 and count 3. But this case says pretty clearly that that's only if it was a short intervening period, that nothing prejudicial to the cause of justice occurred during the separation. Well, we know it was not 5 minutes in this case. It was weeks in this case. And we don't know what they've seen. And we know for sure by juror number 5 that just came out with an affidavit saying that they want the names and the identities and the information about the jurors impounded, that she or he has seen some stuff on social media and is scared about Turtle Boy or whatever other she or he is scared of what else of their name getting out there. So obviously the jurors have already seen, there are news reports, they've seen social media, maybe they've seen brother Counsel. So to say that we can just call them back, just like they did in Lapham versus Eastern Mass, and no problem because you see clearly that they can come back and correct an inconsistency, that's just simply not the case. It's actually a case that helps the state to show that in this specific situation, you can't. Because it's going to imperil the purity and absolute impartiality of the jury, which is necessary before they reach their verdict. So to call them back now, a month later, is not consistent with this case. Again, if I was the defense, I would certainly quote this case, because this case is going to help your cause much more than Commonwealth versus McCallop, where there was racial and ethnic bias. But they didn't quote this case. And like I'm telling you, this case does not help their cause, because in that case it was only 5 minutes. So there's another case called Bridgewater versus Plymouth. And here there was a motion for a new trial, and they had testimony of 2 of the jurors. And it was held to be inadmissible. The jurors in that case said that they misunderstood the instructions of the judge. And the Justice Foster, in delivering the opinion, said the following: the time for objecting to the verdict as announced is when it is received and before it is recorded in open court. To admit afterwards a conflict of affidavits would be dangerous in the extreme and lead to interminable controversy, which is what we're seeing play out in this case. If we're just going to allow jurors to start submitting affidavits weeks after this trial and then say, well, we didn't understand the jury instructions, we thought that you had to find on all the charges, and we only meant the charges in count 2, and we didn't send out a note asking for clarification, whatever. But that's what you're inviting. You're inviting interminable controversy, and it would be dangerous in the extreme. So these two cases really hurt the defense in Karen Reed's case. Now, there's another case. Listen to this case. Commonwealth versus De Benedetto. And in this case, what happened here is that the foreman told the judge that they all voted guilty. They all voted guilty. Okay, if something is going to bother your conscience, listen to this case. Okay, the foreman said we all vote guilty. The judge went back to the jury room, or the foreman recorded guilty. The judge, after excusing the jury, saying thank you for your service, you can go back to the jury room. I'll be in to see you in a minute. Thank you, and to thank you and say goodbye. He went back to the jury room, and the jurors there said that we don't understand why the verdict didn't have to be unanimous. And the judge said, what are you talking about? Of course it has to be unanimous. And they said, well, it wasn't unanimous. So he called the jurors back into the courtroom. Okay? So here you have someone who is just pronounced guilty. His verdict was guilty. The jury, who's still in the jury room, they never even left the jury room. They just went back after court into the jury room. And the judge went in there and said, well, thank you. And they said, by the way, we're not sure why it doesn't have to be unanimous. And he's like, it has to be unanimous. So he saw right away, very clearly, all the jury in that jury room agreed that it wasn't unanimous. This is at the moment. So you would think, what talks to your conscience? That they should be able to come out back to court and say, we were mistaken. We thought it didn't have to be unanimous. We just thought it had to be majority. And now that you're telling us it's unanimous, it was not unanimous. New trial, or we're hung, or we get to go back and do further deliberations. Well, the court held in this case, listen to this. The judge is precluded from inquiring into the internal decision-making process of the jury as a whole or in the individual juror being questioned. Accordingly, evidence that jurors misunderstood the instructions of the presiding judge or that they were induced by misapprehension to assent to the affirmation of the verdict is not going to vacate the verdict. So essentially, the court held in this case, it doesn't matter if afterwards you're telling us that you thought it doesn't have to be unanimous. Even if you're all screaming at the top of your lungs, it was not unanimous. We had a number of jurors who felt that the defendant was not guilty. It's not going to help. It doesn't change it. Commonwealth versus De Benedetto says once they record the verdict in court and the jury's all there, you can't come and take it back and explain that really we were not unanimous. It's really should bother your conscience. Now, it happens to be, in this case, that the judge felt that they should try it again. They tried the case again before it got up on appeal, and he was found guilty completely unanimously. So the fact that maybe there's a guilty person, a not guilty person sitting in prison because of this case is a 2019 case. So, but he was retried, I think, with the same jury, and they did find him completely guilty unanimously. It's just at that point, when they first recorded the verdict, it was not unanimous. But it wouldn't have mattered. That's the point. The point wouldn't have mattered if they would have continued to have this split. Still, once they recorded that verdict the way they did in open court, they can't take it back and say that we misunderstood something, even though in that case it was clear that they misunderstood it. All the jurors said that. So that's what we see from the case law. So the case law, like I said again, is pretty clear that the fact that there may have been confusion and the fact that the jury now wants to come back and say, really, we voted 12-0, that she was acquitted of count 1 and count 3, like I've always said and maintained in my videos in the past, that argument is going nowhere in a hurry. And I know that a lot of people don't like that, but we speak the truth here. And that's what the case law says. It's just what the case law says. I'm sorry. that as we've gone through the case law already in this case, specifically with this motion in the past 3 videos, we've explained the case law, and that's what it holds. So that's why the first argument in this motion that really we should bring the jurors back and they should all tell us what the real verdict was, there's just no basis in the law for that. So I don't see that happening. Again, anything can happen, but I don't see it happening at all. And that's why I always moved on to the second part of this motion, which was the mistrial, was it inappropriate anyway? So nothing to do with the jurors. Maybe the jurors did everything exactly the way they should have, and there was no misunderstanding. But still, maybe you can make an argument that the mistrial was inappropriate. And we've gone through the factors already in our other videos. If you haven't seen those, go check them out. We go through at length and we explain, we do a deep dive. We talk about all the law that has to do with whether a mistrial was declared inappropriately or appropriately. Now, for this specific video, we're going to talk about the jury note because everyone's very hung up about this note. And let's see if that plays in to determining whether the mistrial was declared inappropriately. Now, we already went through the different areas where you can make an argument that this mistrial should have never been declared. Number one, the defense never requested it. As we said very clearly, they never requested it. Number two, did they consent to it? And we spoke about this in the last video, that silence, generally speaking, is consent. The question is, in this specific situation, can they argue that they didn't have an opportunity even to object? And we cited a different case. You can go again to last video and check it out. We cited another case that stood for the proposition that sometimes there was a case where even though the defendant or the defense attorney was silent, still they did not determine that to be or interpret that to be consent because it was so sudden and brief. It was so quick that the defense was just at a loss what to do, so they can't hold that against the defense. But in that case, we explained that it was different than this case because in that case, it was literally in the middle of trial. It wasn't after 25 hours of deliberation where they could already presume that a mistrial may be coming down the pipe and then figure out what they're going to do about it if the judge declares it or whatever. So we distinguish that case as well. But even if we continue down this road and we say, okay, there was no request, and we can argue that there's no real opportunity to object, and therefore there's no consent. Well, then the question is going to be manifest necessity. And everybody's already known it from me. You've seen my other videos. I've explained already manifest necessity a number of times. But let's talk about it now with the jury note. Okay? So the way that you review, maybe there was not manifest necessity because that note did not say that they were hung on all the charges, right? Let's use this argument. Let's even accept the argument, just for argument's sake. Let's accept everyone else's positions here that note only meant they're stuck, that they're hung on count 2. And the judge completely missed the boat here, and really that's what they meant, okay? The way that the Court of Appeals is going to look at the judge's conduct here in declaring a mistrial is an abuse of discretion. That's the standard. So let's get back to the note. You may want to argue that this note shows that they were hung on count 2, and that's it. Is it an abuse of discretion to interpret that note to mean that they're hung on all 3 counts? Okay, I think even the people out there that are arguing that this note meant their only, or at least a valid interpretation of this note, is that they were only hung on count 2. But to say that it's so clear from that note that they're only stuck on count 2 and not on count 1 and count 3, and if you think that, you're so off your rocker that it's an abuse of discretion, I don't think many people out there will agree to that position. I think that at most what they're saying is there's 2 valid interpretations. And if you say that there's 2 valid interpretations, then obviously it's not an abuse of discretion for the judge to side with either one. And therefore, if the judge read that note and understood it to mean, which even according to all of the people that say that it's just count 2, that judge can still interpret the letter the other way, the note the other way, and say that they're hung on all accounts, and therefore there's no abuse of discretion. And that is how the Court of Appeals reviews, and this is in all the case law about manifest necessity. You can look it up. It's in Commonwealth versus Fuentes, and I know I'm pronouncing that name wrong also, but that's the very, very important case, as we explained in the other videos as well. It's in that case, if you want to see, the standard is abuse of discretion. And if that's the standard, then to say that the judge abused her discretion in interpreting this letter, this note, to mean that the jury is hung on all the charges, that is just not reasonable. Okay? I'll give it to you. I'll give it to you that a possible interpretation of this note is that they're only stuck on count 2, but it's not an abuse of discretion to say that the judge interpreted it the other way. And if it's not abuse of discretion, then manifest necessity is you're not going to vacate this judge's. You're not going to say that the mistrial was inappropriate because there was an abuse of discretion. You're just not going to do that. So in terms of this note, what I'm trying to explain to you after 3 videos is that the note makes headlines. It makes a lot of people out there who don't really understand the law get all excited and emotional about it. But if you actually look at this note through the lenses of the case law, it's just not that significant. It's still something to talk about and argue about and have a good time about. But in terms of the law, it just is not that significant. The fact that you can interpret this note to mean 2 things, as we've already explained. So really, like I've always said, the issue really comes down to, did they consent? And if you can make an argument that they did not consent because they didn't really have a real opportunity to object, then it's going to be, how do they get over the case of Commonwealth versus Fuentes? And in that case, and maybe it's Fuentes versus Commonwealth, I forgot already at this point, but the question is going to be, how do you distinguish between that case and what happened in Karen Reed? Because in Commonwealth versus Fuentes, they found that the mistrial was proper, and it's almost exactly mirrors the same facts that happened in Karen Reed. So, like I said before, I think Fuentes is wrongly decided. I don't think that it fits with all the other case law in Massachusetts. Nevertheless, it is a case. It has some presidential value. So they're going to have to do something with that case. So again, assuming that they get past the consent issue because they didn't object, because you can make the argument that they didn't have any real opportunity to object. Maybe you can make that argument. Again, I don't think it's the greatest argument, but you can make that argument. Still a palatable argument. I think that could be made. The question is going to be, what are they going to do with the Fuentes case? And we've already spoken about this. You can look at my last video about that specific argument, what to do about that. But that's going to be it for today. Thank you all for watching. Please, if you haven't, subscribe, like, and we will see you next time.